Addenda. Additional material attached to and made part of a document. Amendment. Used to change the terms of a contract. Cancellation agreement and mutual release. A document used to terminate a contract of sale or agency agreement when the parties mutually agree to terminate their original statement. Counter offer. An offer which essentially terminates a prior offer and states only the new terms to be negotiated. Multiple counterproposal. A way for a seller to negotiate in writing with more than one buyer at a time. Notice relating to the offer to purchase. A form used by the parties to a purchase contract whereby one party is unilaterally giving notice to the other party. Approved form. A contractual or conveyance form which is prepared and approved by the Department of Safety and Professional Services. Bilateral contract. A contract which binds two parties. Two promises are given when in exchange for another. Breach. A failure to perform as promised in a contract. Competent parties. An essential element of a valid contract requiring all persons involved in the contract to be of legal age and sound mind. Consideration. One of the elements necessary to form a valid contract. It may take the form of good or valuable. Contingency. A provision in a contract that requires the completion of a certain act or happening of a particular event before that contract is binding. Contract. A legally enforceable promise or set of promises that must be performed and for which if a breach occurs, the law provides a remedy. Damages. Compensation recoverable in a lawsuit by a party who sustained an injury. Express contract. A contract created by the parties stating their intentions either verbally or in writing. Good consideration. A legally sufficient promise made by the parties of a contract. Implied contract. A contract created between parties as evidenced by their actions. Liquidation. A remedy for breach of contract which is available only to the seller, whereby he/she retains the buyer's earnest money as damages. Meeting of the minds. Mutual assent or agreement between the parties to a contract regarding the substance of the contract. Parole evidence rule. Prevents the admission into court evidence of any oral negotiations or agreements that vary or contradict the terms of the written contract. Specific performance. An action brought by a court to force a party to carry out the terms of a contract. Statute of frauds. The statute requiring all contracts which transfer an interest in real estate to be in writing, state the date, describe the property, state the terms of payment, and be signed by the party incurring the debt. Time of the essence. This specified date in the contract by which agreed upon acts must be completely performed or the non-performing party will breach the contract. Unenforceable contract. A contract whereby neither party can sue the other for performance. This type of contract may be valid between the parties by mutual agreement. Unilateral contract. A one-sided agreement where one party makes a promise to another and is bound by the promise. The second party is not bound. Valid contract. A contract that contains all of the necessary elements and is enforceable in a court of law. Valuable consideration. Something of monetary and legal value that is given in exchange for a promise. Void contract. An unenforceable contract that lacks legal purpose or essential requirements. Voidable contract. A contract that can be voided by an injured party.